Good morning, Your Honour. I appear on behalf of the claimant here today, whom in this case is Mr. Spitali, and the defendant is represented by my learned friend Miss Wong. The application here today is pursuant to CPR 25.71C, whereby the claimant seeks an interim payment in the sum of £20,000. May I just ask, has the court received the skeleton argument, including the authorities in the bundle, and had a chance to read those? Thank you, Your Honour. Your Honour will see at paragraph 2 of the skeleton a list of authorities that I will be relying on here today on behalf of the claimant. And if you will scroll to paragraph 3, Your Honour, of the skeleton argument, you will see all the way up until 7, paragraph 3 to 7, an outline of the facts of the case. I don't propose to take the court through those at this point in time, unless Your Honour wishes me to do so. However, in summary, Your Honour, the claimant suffered personal injuries involving the defendant in a road traffic accident. The claimant was the rider of the motorcycle and the defendant was the driver of the car. It is the claimant's position, Your Honour, that the accident was caused by the defendant's negligence and breach of statutory duty, which I will address later on in this application. If I may ask, Your Honour, if you could turn to paragraph 8 of the skeleton, where I lay out the test for the CPR 25.7 that this application will be relied on. You will see, Your Honour, in the skeleton as a whole that there are 3 main submissions that will be addressed here today based on this exact test. Firstly, proving if the claim went to trial, whether the claimant would obtain judgment. Secondly, whether the judgment would be for a substantial amount of money other than the costs against the defendant. Thirdly, whether the likely amount of the final judgment would be a reasonable proportion, and lastly, taking any contributory negligence into consideration. However, Your Honour, before I move on, I'd just like to address the substantial element first, if I may. If I can ask you to turn to paragraph 17, you will see all the way to paragraph 21 where the substantial element is addressed. As the claimant is in early stages of the case, Your Honour, there are further medical evidence that is required. So at this present time, the parties have actually agreed the minimum amount for general damages and past losses subject to liability, which is for at least £45,000, and costs are only likely to increase from this point, Your Honour. So it is the claimant's position that the element of the test for a substantial amount is satisfied, as it's not contentious, and it's only £20,000 that the claimant seeks today. So essentially, Your Honour, this application will be more focused on as to whether the claimant would actually obtain judgment if the claim went to trial, and then addressing the reasonable proportion element. Your Honour, if I could just turn your attention back to paragraph 9 of the skeleton where the test is laid out. So the court is invited to consider the application in 2 stages as laid out in the case of Shotkem and Bentley. The court must first be satisfied on the balance of probabilities that if the action proceeds to trial, the claimant will obtain judgment for a substantial sum, and if so, the court should then consider whether in its discretion it should order an interim payment. If I may, Your Honour, I'll just now move on to address my first submission in proving that the claimant would obtain judgment. So the claimant's first submission is the fact that the defendant failed to keep any adequate lookout, Your Honour. The claimant was wearing a fluorescent yellow biker jacket, helmet and gloves, as confirmed by an independent witness named Mrs. Khan at paragraph 5 of her witness statement, and this is also included in the pre-reading at paragraph 2, Your Honour. The Highway Code also recommends to wear all of this simply for safety, but also to ensure that the motorcyclist stands out. Your Honour, I'd just like to draw your attention specifically to Rule 86 of the Highway Code that I mention at paragraph 10A of the skeleton, where it specifically states that make yourself as visible as possible from the side as well as the front and rear You could wear a light or brightly coloured helmet and a fluorescent clothing or stripes. So evidently, Your Honour, the claimant was in clear sight, or at least ought to be. There was nothing obstructing the defendant's view. The road was very clear, straight, and therefore the defendant ought to have seen the claimant. Which just takes me into my next point, Your Honour, at paragraph 10b of the skeleton, that just because the traffic was stationary at the time, or at least moving very slowly, it does not absolve the defendant to keep an adequate lookout. Your Honour, the defendant has a duty of care just as much as other road users to keep an adequate lookout, especially to those that may be less visible to see than a car, which is supported by the rule, by Rule 151 of the Highway Code, as mentioned in my skeleton at paragraph 10b, Your Honour. Which just takes me into my next point at paragraph 10c, that the defendant must not have been adequately checking his mirrors if he did not see the claimant as he claims. Your Honour, I've mentioned at paragraph 10c that the defendant addresses between paragraph 5 and 7 of his witness statement and alleges that he did not see the claimant because of the claimant's speed and the claimant allegedly not paying attention. However, Your Honour, I'd just like to make the court aware that that road is a 30-mile-per-hour zone, and the claimant was travelling well within this at roughly around 20 miles per hour. And this is actually supported by the independent witness, Mrs. Khan, at paragraph 6 of her witness statement. And we also know this because Mrs. Khan mentions that she was stationary in traffic. She was 2 car lengths away from the defendant at the time of the accident. She watched the claimant travel past, had time to actually discuss with her husband what the claimant was even wearing, all before the accident occurred, which just shows, Your Honour, that evidently the claimant was not speeding. He was concentrating on the road and its conditions, and the claimant did not have and was not in a rush to get to his destination either. And therefore, Your Honour, the defendant did not clearly adequately check his mirrors, otherwise he would have seen the claimant. And I'd just like to draw your attention, Your Honour, to the case of Butcham and Whiting, which I mentioned at paragraph 10c of the skeleton. The court's, this is a similar personal injury case, Your Honour, concerning the claimant who is a motorcyclist who overtook slow-moving cars. The defendant turned right out of the side road and a collision occurred. And although the claimant was actually speeding in this case, the court actually held at paragraph 35 that the claimant would have been visible for some 200 metres to the concerned observer, whatever his precise position on the road. And we take from this case, Your Honour, that despite the claimant's position on the road in this instance case, that he should have ought to have been seen by the defendant, even though he was close to the defendant. Your Honour, and this is also supported by the Rule 159 of the Highway Code that I mentioned at paragraph 10d of the skeleton, where it clearly lays out that you must always check your mirrors, and upon that final check, which the defendant must not have done, otherwise he would have seen how close the claimant was to him. Your Honour, just in respect to the defendant's failure to drive with due care that I address at paragraph 11, Your Honour, as supported by the independent witness Mrs. Khan at paragraph 7 of her witness statement, the defendant began his manoeuvre quite suddenly and very swiftly, which Mrs. Khan perceived as an act of impatient reaction due to the slow-moving traffic, Your Honour. This is a quite unsafe move to conduct, and as supported by the case of John Lunt and Bakia Khalifa, Your Honour, the court actually held at paragraph 20 that nonetheless, bearing in mind the fact that this court has consistently imposed on the drivers of cars a high burden to reflect the fact that a car is potentially a dangerous weapon. And we take from this case, Your Honour, that considering a car is a potentially dangerous weapon, this is more reason why the defendant should have taken more care on the road when conducting his manoeuvre. And this just takes me into my next point, Your Honour, that the defendant did not consider other road users when carrying out his manoeuvre, and quite clearly not vulnerable ones as the claimant, and and the claimant who suffered as a result of the defendant driving without due care and attention. And I'd just like to draw your attention to paragraph 211 of the Highway Code that I mentioned, Your Honour, at paragraph 11b of the skeleton. It clearly shows that it's often difficult to see motorcyclists and cyclists, but the defendant did not consider this, Your Honour, and therefore he was clearly just not driving with due care and attention. I'd just like to draw your attention to the case of Davis and Troggin that I mentioned at paragraph 10c of the skeleton, Your Honour. This is a very similar case, this instance, almost identical, Your Honour, where the defendant was stationary in a traffic jam when he decided to execute a U-turn to get out of the traffic jam. The defendant evidently collided with the claimant, who was filtering past on his motorcycle as he did not see him. The trial judge found that once the defendant executed his turn, the claimant's proximity meant that the collision was inevitable, such that liability should rest 100% with the claimant. This case then went to the Court of Appeal, Your Honour, who actually agreed with the trial judge and did not interfere with that decision. And therefore, Your Honour, we take from this that, the claimant clearly did not have any time to take any evasive action to avoid the collision. And therefore, Your Honour, the defendant clearly was not driving with due care and attention. Which just takes me onto my key point, Your Honour, in this application, is the fact that the defendant subsequently also breached his statutory duty due to all of this, as mentioned, of the Road Traffic Act 1988, Section 3. It states that if a person drives a mechanically propelled vehicle on a road or other public place without due care and attention, or without reasonable consideration for other persons using the road or place, he is guilty of an offence. And it is submitted that, Your Honour, that if the defendant had drove with due care and attention, he would have avoided the collision and he would have not subsequently breached his statutory duty as a road user. In respect, Your Honour, to the defendant's failure to provide sufficient warning of his right turn, which I address at paragraph 13, it is clear from the claimant's account, Your Honour, and from Mrs. Khan, the independent witness, that the defendant did not signal at an early opportunity in order for the claimant to take evasive action. Rather, the defendant just signalled and then immediately turned right. Your Honour, any reasonable person would keep a proper lookout, check their mirrors effectively, signal at an early opportunity, and actually provide sufficient warning to other road users that the defendant is about to take the right turn, and then make a final check in his mirrors upon doing so. And upon all of this, one would be driving with due care and attention. However, Your Honour, the defendant failed to do all of those. And I'd just like to draw your attention to the case of Aviva Insurance that I mentioned at paragraph 15, which is also in the pre-reading at paragraph 2. This case is similar to this instance, Your Honour, involving a motorcyclist, his pillion passenger also, and the car driver. The courts in summary concluded that the expected standard of care of a driver should be higher when carrying out a manoeuvre in the middle of a main road, which takes me back to my earlier point, Your Honour, in reference to the case of Davis. Because a car is also a potentially dangerous weapon, there should be this high standard of care expected of drivers. And in conclusion, Your Honour, based on this submission, it is admitted that the claimant has satisfied Rule 25.7 of that part of the test, and therefore it is more than likely that the claimant would obtain judgment at trial. Your Honour, just in regards to the substantial amount element, as mentioned earlier on, it is not contentious, and therefore the claimant submits that this is satisfied. In respect of the reasonable proportion, Your Honour, as mentioned at paragraph 22 of the skeleton, this is the second part of the test. I would like to kindly remind the court that it is at the court's discretion as to what amounts to a reasonable proportion, as supported by the case of Darman and Rowe. As the defendant has denied liability, Your Honour, or at least in very part, The court must then consider if there's any possible contributory negligence on the claimant's part. The defendant asserts that the claimant was speeding, which is the reason for the defendant not seeing the claimant, as mentioned earlier, which is why they were unable to avoid the collision. However, despite evidence showing the claimant was filtering through at a low speed, as earlier mentioned, it is submitted, Your Honour, that only in exceptional circumstances will there be a finding of contributory negligence of a small apportionment. And this is supported by the case of Chevron and European Metal Recycling Limited. This is a similar case, Your Honour, between a motorcyclist and a lorry driver colliding. Though in this case, the motorcyclist was in fact speeding, it was held that the defendant's conduct was more negligent than the claimant's, as the defendant took a higher risk. And of course, Your Honour, these are extreme circumstances considering that a lorry is a larger vehicle. However, what we take from this, Your Honour, is that even if the claimant was speeding in this case, it is highly unlikely that the claimant will be found more negligent. And as also supported, Your Honour, as I mentioned at paragraph 26 of the skeleton, supported by the case of Davis, as earlier mentioned, it was held at paragraph 11 of this case that once it is held, as the judge was plainly entitled to hold, that the claimant was so close to the point of impact that he could not avoid the collision, then there is simply no basis for any finding of contributory negligence. As this part does in fact apply in this instance directly, Your Honour, to the claimant submits that he was unable to act, and that it is therefore highly unlikely that the claimant will be held contributory negligence. As Your Honour, I mentioned at paragraph 27, Your Honour, of the skeleton, as the claimant only seeks an interim payment of £20,000, it is submitted that this is a reasonable and proportionate amount, which is less than 50% of the lower likely judgment sum at this present time, taking into consideration a higher proportion of contributory negligence in the unlikely circumstance. And therefore, Your Honour, the claimant respectfully requests the court to order an interim payment of £20,000. If there are no further questions, Your Honour, those are my submissions. Thank you.